This week at the Supreme Court. The Supreme Court, during its en banc session on March 18, 2025, noted without action the motion for reconsideration filed by petitioners, former President Rodrigo Roa Duterte and Senator Ronald Dela Rosa, regarding the denial of their prayer for the issuance of a temporary restraining order. It also ordered Executive Secretary Lucas Bersamin and other respondents to file their comment within 10 days on the new matters raised by petitioners in the supplement to the petition seeking the former president's release from detention at the International Criminal Court. Still on the arrest of former President Duterte, the court has directed petitioners Sebastian Veronica and Paulo Duterte to file a traverse, which is a denial of facts alleged in the opposing parties' pleadings, within 5 days in response to the consolidated compliance of Department of Justice Under Secretary Nicholas Felix L.T. to the court's March 13, 2025 resolution. Under Secretary T has been authorized to represent the respondents in the case following the Office of the Solicitor General's recusal. The SC also rescheduled the oral arguments on the following: April 2, 3, and if necessary, April 4, 2025, for the petitions regarding the transfer of excess funds of the Philippine Health Insurance Corporation or PhilHealth. May 19, 2025, for the petitions challenging the constitutionality of the General Appropriations Act of Fiscal Year 2025. And July 8 and 9 for the petitions challenging the validity of the Maharlika Fund Act of 2023. In a recent decision, the SC has also ordered the Dakak Beach Resort Corporation and Romeo Jalosjos to vacate a 1,602 square meter property in Dapitan City, Zamboanga del Norte, which they had been leasing. It also ruled that all permanent structures built during the lease now belong to the landowner. Through Associate Justice Alfredo Benjamin S. Caguiwa, the SC's 3rd Division ordered Dakak and Jalosjos to return the land and the permanent structures built on it to its owner, pay unpaid rent, and settle 1.5 million pesos in damages. The court ruled that Dakak had no right of redemption over the land, as the adjoining lands owned by Dakak are used for commercial purposes and not for rural purposes. The court also held that Dakak was not entitled to reimbursement for the structures it built, given that the lease agreement expressly stated that ownership of all structures would transfer to the landowner at the end of the lease. In another case, the court held that lawyers cannot be held liable for notarial violations unless there is clear evidence that they knowingly permitted the misuse of their notarial commission. In a decision written by Associate Justice Ricardo R. Rosario, the SC's 1st Division dismissed the administrative complaint against 2 lawyers due to lack of proof that they allowed the unauthorized use of their notarial signatures, notarial seals, and notarial registers for a fee. The Notarial Practice Rules prohibits notaries from notarizing documents if the signatory is not present and properly identified. The administrative complaint stemmed from the alleged notarization of documents related to criminal cases filed before the Office of the Ombudsman concerning the Maharlika Fund scandal. In another decision, the SCS held that a teacher may be held liable to pay damages for harm caused by a student under their supervision if they did not exercise due diligence in preventing the incident. The SC's 1st Division, through Associate Justice Ramon Paul L. Hernando, upheld the liability of Gil Apolinario, principal of an elementary school in Santa Margarita, Samar, for damages arising from the death of Francisco de los Santos. Apolinario instructed a 15-year-old student to cut down a banana plant near the school and on the side of a highway. The plant fell and struck de los Santos, who was passing by on a motorcycle, leading to his death. The court held that Apolinario, as the teacher in charge, is vicariously liable for damages. It ruled that teachers and school heads are responsible for the actions of the students while under their supervision, even outside school hours. Meanwhile, on Tuesday, March 18, Chief Justice Alexander G. Hismundo and the Associate Justices were paid a courtesy visit by His Excellency Endo Kazuya, Ambassador of Japan to the Philippines, at the en banc session hall. Chief Justice Hismundo and Ambassador Kazuya discussed digitalization and modernization efforts and strengthening judicial ties between the two nations. Joining the Chief Justice were Senior Associate Justice Marvic MBF Leonin and Justices Henry John Paul B. Intin, Samuel H. Garlan, Ricardo R. Rosario, Japar B. de Mampao, Jose Midas P. Marquez, and Antonio T. Co. Jr. On Thursday, March 20, the Supreme Court conducted a consultation on the proposed rules on Filipino Sign Language, or FSL interpreting in the Judiciary, at the University of the Philippines Diliman College of Law in Quezon City. The consultation was spearheaded by the Technical Working Group, or TWG, to draft the rules chaired by Associate Justice de Maampao. The event brought together around 100 participants from across the country, including trial court judges, representatives from advocacy groups for the deaf, FSL interpreters, and individuals involved in FSL training and education. Finally, on Friday, the SE held the kickoff event for the Performance Development Framework for the High Performance Courts in pilot courts in Angeles and Macabebe, Pampanga. The project aims to ensure the creation of an environment of excellence in court performance, both qualitatively and quantitatively. The virtual framework will enable courts to track and evaluate their individual performance and make use of tools and trainings in order to make improvements. The event was led by the Committee on First and Second Level Courts Performance Evaluation, headed by Associate Justice Kagiwa and the Office of the Court Administrator. And that's your Supreme Court this week. I am Tiffatin D. Doblatran, Supreme Court Information Officer.